Thanks everyone for joining. I think that we're going to see some folks trickling in as we go. We do have a lot of folks signed up for this webinar, and thank you so much for attending, taking time out from your busy schedules. But I'm sure that you find the information that we're going to provide today to be as exciting as I find it to be. So welcome to H-1B season. As many of you know, we are in the midst of preparing H-1B non-immigrant work permits for employers and beneficiaries, which needs to be filed starting on March 4th. And that period of time, that window opens on March 4th at 12 o'clock noon and closes on March 19th at 12 o'clock noon. So that's the recent announcement. So my name is David Nachman. I'm one of the managing attorneys at the NPZ Law Group, and I'm joined by my partners, Lutka Zimochek and Snehal Batra, who I hope are going to introduce themselves in a moment. But I'm just going to quickly tell you that the NPZ Law Group corporate offices are located in Ridgewood, New Jersey. And we also have offices in Raritan, New Jersey. We have an office in Florida, an office in Toronto and Mississauga, outside of Toronto in Canada. And we handle the full spectrum of immigration law services, including I-9 and compliance work for employers. And I'm going to turn it over to my law partners to introduce themselves. Lutka, you want to quickly introduce yourself?
Sure. Thank you.
Thanks.
My name is Lutka Zimochek. Also, I'm an immigration attorney, and I've been practicing for close to 20 years. So I handle employment-based immigration, family-based immigration, all kinds of humanitarian cases. So, full spectrum of immigration law. And I look forward to being here and hopefully tell you a little bit more about the upcoming H-1B season.
Great. Sneha?
Okay, sure. Thank you. Good morning, everyone. Thank you for joining us. I'm Snehal Batra. My office is in Raritan, so I'm in Somerset County, and I too do employment, family law, immigration. And this past year has been very hectic, lots of changes, and one of them being this new H-1B rules. So we're going to talk to you about that, and we hope you have some good takeaways from our webinar today. Thank you.
It's great. Thanks so much, Snehal. So, Snehal, actually, you sort of stole a little bit of my thunder, and that is that I wanted to just let everyone know that the H-1B season has never been so exciting. I mean, this year, not only are we dealing in the throngs of change, but the major overlays are that we're in the midst of a travel ban, partial and full travel ban. We also have a travel pause, not to be confused with a travel ban, for 72 countries. We also have 75. Thank you, Lutka. We also have the $100,000 fee, which was announced in September for individuals who are outside the United States who will be coming back in potentially on H-1Bs, and we'll tell you a little bit more about that. And we have the implementation of a weighted salary methodology for choosing registration in the H-1B lottery. So all of this makes for a recipe for a perfect storm. And it has been nothing less than that for us because we obviously are working our way, through these issues with our clients who are interested in registering their employees for the H-1B lottery. So with that, what I want to do is just quickly point out, this is the disclaimer. This program is obviously for educational purposes only. We are not providing legal advice. We're providing general educational advice. Immigration rules and policies may change like they have every single day. In fact, yesterday we got this wonderful, I got a 14-page practice pointer, and we have a lot of really good information that comes out of that actually for you with regard to, how the electronic registration is going to be working. And needless to say, if any of you have heard us speaking before, which hopefully many of you have, case outcomes depend upon specific facts and circumstances. And, you really need to look at your own personal situation based upon your own personal facts, circumstances, backgrounds, etc. There's a lot of really bad information out there right now, especially because, there is a general mood of fear that's being promoted, of course. And because of that, folks are looking for answers. And there are obviously a lot of people who will give answers, but a lot of those answers are not correct. And you have to be really careful. So, for those of you, again, who have heard us speak, we've always said try to stay to good information. We try to put out as much information, good information, as we can on our blog sites. Please feel free to visit our website. I believe it's right above my head here. It's visaserve.com. And we are posting as quickly as the information is coming out. But also keep to the government websites. Government websites are a great source of information. Basically, when folks come to me and they tell me that they got advice from their friends, the hair on the back of my neck goes up. I get very scared when I hear that. So just be really careful where the information is coming from.
But
So,
unfortunately, there are a lot of scams as well. We recently
yes.
heard, that some of our clients, when they came, they said they saw attorneys, and then we found out they were not attorneys. In fact, they even said they had interview and they were in front of the immigration judge on Zoom. And of course, that was not immigration judge. It was just the whole scheme. So be very careful who you talk to. Even if you think it's an attorney, maybe you want to double check that they are, in fact, a law firm, an attorney, because a lot is going on, unfortunately.
And Snehal, any words on what you've encountered apropos bad information out there that we can?
I mean, I think that immigration is particularly a field where you have so many different moving parts from attorneys, employers, family and friends, and media. So there's information all over the place constantly. So again, make sure that you are getting your information from a legitimate source and seek advice from an attorney.
That's great. It's great advice. And so today we're going to talk about H-1Bs, and obviously then we're going to get into the registration process and the filing process. And for those of you who have heard me speak in the past, you know that I'm a little bit of a history buff. It's also because I've sort of lived through the history of the immigration process. So I go back, believe it or not, I go back to 1988, 1989, when I was doing H-1Bs, and there was no cap, believe it or not, on the H-1B process. So I was submitting H-1B after H-1B. And then what happened in 1991 under IMAC 90, we had the implementation of the Labor Condition Application, the LCA, which is where the US Department of Labor sort of got involved in the H-1B process. And then what happened was they put this cap, the 65,000 cap on the H-1Bs. And again, this goes back to 1990, 1991. And what they did was they created, because they put that cap on the H-1Bs, they created these new classifications of visas to allow for people to go into other areas, such as the O, the P, the Q, and the R visas. These were all created out of IMAC 90. Now, what happened was the LCA was created for the purposes of assuring that US workers were not going to be displaced. And this is the same common theme that we even see today, is that it's, the implementation of these changes in the H-1B realm have to do with the ability to make sure that the H-1B is not being used to displace US workers. And in fact, the displacement of US workers using the H-1B process is a bit of it's a bit of what we call a red herring, because with the LCA, the labor condition application that gets posted, it protects US workers to make sure that individuals, foreign nationals, are not being paid below the federally mandated prevailing wage. Okay, so that's what the LCA did, is that the implementation assured that individuals, foreign nationals who were getting the H-1B were being paid at the federally mandated prevailing wage. So it's an interesting history. Before we get into a little more of the, I guess we'll say the substance of this, I think it's important for everyone to understand what the H-1B is. First of all, the H-1B is the workhorse of, what we refer to as the alphabet soup of visas, and the reason for it, of course, is because it under what's called AC-21, the American Competitiveness in the 21st Century Act, what it did was it allowed individuals to get and to keep H-1Bs beyond the 6-year period and to keep it until such time that they got green cards. And that was important for individuals from China and from India who have tremendous backlogs that they need to be concerned about. So basically what the H-1B visa is for individuals who are professional level workers coming to the United States to perform specialty occupation work. And actually, if you look back, and again, historically, there is a case that deals, it's called Essex Cryogenics, that deals with the definition of what is considered to be a professional. That's a 1975 case that deals with what is considered to be professional. But basically, the definition of professional means that the individual has to have the equivalence of a U.S. baccalaureate degree. And then, of course, in terms of being in a specialty occupation, the job offer has to require a bachelor's degree, and that there are a couple of different ways that you would look to whether or not the individual has the bachelor's degree. So one can be, does the individual have the bachelor's degree? Because if they have a U.S. bachelor's degree, of course, they have the equivalence. Two, do they have foreign academic credentials that equate to having a bachelor's degree? Three is that they might have the experience that's necessary. If they have the experience, it's using what's called the 3-to-1 rule, which is in the regulation. So 3 years of work is equal to 1 year of bachelor's degree level educational equivalence. Or you can have what's called a combination of academic and experience, and then we would go to an academic evaluator to make that determination as to whether or not it equates to a bachelor's degree. Okay, we'll go to the next slide. Thanks. So there are some examples, and they're pretty straightforward for occupations that are considered to be professional and specialty occupations. It's really sort of common sense. Chemists, biologists, engineers, physicists, software developers, systems analysts, accountants, etc. So they're all listed. Many of them are listed here on this, but this is not exhaustive by any means. But the ultimate question is a bachelor's degree or its equivalent required for the position? So this is the big question. And what we would do, and usually, thank you so much, what we usually do is we look to a couple of different resources to make a determination as to whether or not a position is considered to be professional in nature. So the first resource that we look to is a U.S. Department of Labor publication, which is available online. It's called the DOT, the Dictionary of Occupational Titles. And each job that you can possibly imagine is listed in a 2-volume collection. One volume has to do with non-professional positions. The other volume has to do with professional positions. And each job has associated with it what's called an SVP code. And the SVP code is a specific vocational preparation code. So if you have a specific vocational preparation code of 7 or more, then that is deemed to be professional. We also have what's called the Occupational Outlook Handbook. It's another publication, which is sort of the sister the sister publication of the Dictionary of Occupational Titles, and there are narratives in the beginning that describe SOC codes. And we'll get more into SOC codes because for this year, SOC codes is a very, very important consideration for employers because you have to designate these SOC codes now in the registration. In the past, we didn't have to be as concerned about it. Maybe that this issue reared its ugly head on a request for evidence, but now we're going to have to designate this information up front. So we also have another resource that we would look at. It's called ONET, and ONET has job zones, and job zones of 4 or greater are considered to be professional in nature. ONET is what I refer to as the Dictionary of Occupational Titles on steroids. It's available online and has a nice crosswalk also to prevailing wage determinations. So it can help you understand what prevailing wages are and how they work. And we'll talk a little bit more about that. Additionally, what we can do is look to comparable positions in newspapers or online listings, and that would help us determine whether or not a position is professional in nature. But ultimately, again, it's really about whether or not the employer requires a bachelor's degree or its equivalent for the job. So basically, an H-1B, by the way, is the subsection within the statute that talks about this professional visa and then the regulations also. And that's why it was designated as an H-1B. So it is good for an initial grant of 3 years with a 3-year extension. Any time that's spent outside the United States, you can recapture, which means even if you spend the weekend in Mexico or you go to the islands or you go back home for a week, that time can be recaptured. And you might think that that's not important, but that recapture time can be critical, especially when we're trying to do strategic planning for the green card. To get that time back is really, really important. And so for individuals who initiate the green card process, and this is one of the reasons why, we work very closely with employers, especially when they have staff from India and China, is because we want to get them in a position where they at least have an I-140, which is part of the green card process, approved so that they can get incremental extensions in 3-year increments beyond the 6 years that the normal H-1B is available in order to carry them from the time, until the time that they actually have their green cards. Okay. Thanks. So H-1Bs are employer specific, which means that the employer drives the process. There is also something that is called concurrent H-1Bs, and we'll tell you a little bit about why that's important. Concurrent H-1Bs means that you can have more than one H-1B at a time. We actually have a client who has 5 H-1Bs, and that's because he has a very discrete skill set that is desired by multiple corporations. And so he's able to take compensation from each one of those corporations that he has a concurrent H-1B with. H-1Bs are portable, which means that you can move them to a new place of employment. And if you move it to the new place of employment using Section 105C of AC 21, you can actually start work even before the H-1B petition is approved. And something that a lot of people don't realize is that part-time employment on an H-1B is permissible. And this is especially important now, given the current consideration of the wages, especially in light of what is required for registration and how that is going to be streamlined into the H-1B filing process. Okay, and with that, I believe, Ludga, you're going to cover some additional
let's talk
information.
about who should be applying, who should be looking at H-1B case. So we have a time. So just to go over a few categories, of course, students. We see, I would say majority would be students on OPT or STEM. OPT applying for the H-1B, that's the typical case. But we also have any type of F1 students that would be qualified if they already have US bachelor's degree, or as David mentioned, they may have a foreign degree that is equivalent to the US bachelor's degree. Please remember, we get this question all the time. the individual or the applicant does not have to be working for that employer at the time. So, we could have a student that is currently pursuing, for example, a master's degree, that perhaps has an offer of employment. It's possible to proceed with the H-1B. It's really important to remember that. We also have TNs. It's a good idea, especially if there is a plan to proceed with the green card. I'm not sure if we addressed it, but H-1B is a dual intent type of visa. So it's really strong. It has immigrant intent. TN does not. So oftentimes, for those in TN pursuing green card process, it's not a bad idea to enter them in the H-1B lottery. The same goes with dependents. So if there are companies that, have employees that are on H-4s, L-2s, it's probably a good idea to think about the H-1B so they have independent case, because just in case something happens to their spouse, they lose the job, then they will lose their own status as well. The same goes for L-1A and L-1B, as David was explaining the retrogression for Indians and Chinese. Sometimes the max time for L-1A, which is 7 years, and 5 years for L-1B, is not enough to obtain the green card. So sometimes strategically, it's really important to switch over to H-1B, because with the H-1B, they could renew the H-1B beyond the 6 years. Now, as far as humanitarian programs such as TPS, DACA, and even employees overseas, it's a little bit tricky. It's case by case because of the 100,000 rule. I know Snehal will talk about it a little bit more, but definitely worth to look into, especially with the TPS, because a lot of countries, there is a termination of the TPS. And of course, if, previously somebody was not successful in the H-1B lottery, they may want to try again. So these are just some examples on who can consider proceeding with the H-1B lottery. Just one little fact, it's not the applicant that is doing the registration, obviously. It's the company that needs to do registration. We get this question quite often. So David explained how the cap was established and why. And I actually do remember that even though there was a cap, that there was no lottery in 2008, I think 2009, perhaps it started. So there is definitely a huge demand for H-1Bs because there are only 65,000 per year. We do have additional 20,000 for those that have U.S. master's degree or higher degree. So in total, we have 85,000. And if you look last year, there were over 340,000 H-1B registrations. The year prior to that, even more. And I think 2 years ago, it was close to 800,000 H-1B registrations. So because of that, we always have lottery every year. But I want to say maybe 5, 6 years ago, they came up with the H-1B registration, which is nice because historically we had to file the full H-1B case on April 1st. And for those of you that don't remember it, it was interesting because all the cases had to be filed on April 1st. So let's talk about the lottery and registration. As of last year, it is a beneficiary-centric selection process, which is great. That's why we have a lower number compared to 2 or 3 years ago. So right now, the way it works, even if there are 5 different companies doing H-1B registration, it only counts as one because it's one unique beneficiary. So that's what beneficiary-centric selection process is, because there could be several organizations that are doing H-1B registration for one person. But again, it only counts as one. And now, as of this year, and I'm going to discuss it a little bit later, we do have the weighted selection process as well, coupled with this beneficiary-centric selection process. We still have the regular and U.S. master's cap that didn't go anywhere. We still have that. So obviously those with U.S. master's degree and higher have a better chance in a lottery. As far as the registration process, David mentioned it's March 4th until March 19. It's really important that companies do not miss this registration period because it just happens once a year. So if you miss it, you have to wait one more year. The fee is $215 for the beneficiary, and the electronic submission for the registration can only be done through USCIS account. The applicant will not have access to the results. The selection takes place at the end of March, and then the employers, the companies that did the electronic submission, will be notified who was selected. And obviously, only those that were selected will be able to file the H-1B petition. For those that are not selected, it will just show that it's submitted. It's always possible that there will be a second lottery. We've had that for the past few years. Usually it's like later in summer, August. I think maybe 2-3 years ago, we even had a third lottery. But of course, it's not possible to register for second lottery. You have to register in March. So it's really, really important. One little fact, for those that are currently pursuing master's degree, they could go under master's cap, even though they wouldn't graduate in March. Typically, graduation is in May. So that is okay. They can go under US master's cap. But it's really important that if selected, the H-1B is filed after they graduate. So even though, the filing starts on April 1st, for those that will graduate in May, they will have to wait. That is really important. So let's talk about the key change, the big change that happened recently with the final rule that will actually be effective on February 26th, just in time for H-1B registration season. The way it works, the higher the salary or the offered wage, the better chance in the lottery. So Department of Labor has 4 levels, level 1, 2, 3, 4 of the wage. Level 1 is the lowest. And if the offered wage matches level 1 or it's higher, then the applicant will get 1 chance in the lottery. And it goes, with the level 2, 2 chances, 3 chances, and the highest, which is level 4. So if the offered wage matches the level 4, then the person will have 4 chances in the lottery. I'm going to skip a little just to show you the chart. What's the probability? So it's definitely, pretty high chance comparing to level 1 if you look at the level 4 for the weighted selection compared to last year. So those that can meet the level 4 will have a good chance. It's still random. It's just a higher chance, of course. So it doesn't matter what country the applicant is from. It doesn't matter what position. It doesn't matter what type of position. The only advantage there is the higher salary. And then, of course, the master's cap. Then the individual would have a better chance in a lottery. So what changes for the companies? A lot is changing. This is definitely, they revamped the whole registration. A lot more information is needed. So other than basic information about the company and contact person and address, we now also need information about the job itself. David discussed the SOC code, which is the occupational code that needs to be finalized now for the registration. It actually needs to be entered. And that shouldn't be changed later. So it needs to be consistent. So if selected on the H-1B petition, it needs to stay the same. Obviously, wage level will have to be indicated in the registration, and location. It's really important to know worksite. Now, if there are multiple work sites, let's say the individual will be working in New York and also in Pennsylvania. And it's possible that with the offered wage, it will meet maybe level 1 for New York, but level 2 for Pennsylvania. Well, we will go with the lower level. The rule is that it would be a lower level. Similarly, the same goes for multiple employers. So if the applicant has, let's say, 2 companies that are doing H-1B registration, and one is using level 1, the other one is using level 2, it will be the lower level. So the rule always is the lower level. Also, I just had a discussion with somebody. If somebody is working remotely, let's say they work partially from home and then from the office. So there would be 2 locations. The same rule applies. So whichever is the lower, that will be used for the lottery. So there's definitely less flexibility to make changes later, but it's definitely possible that there will be a different level, because for the purposes of the registration, there is going to be the level based on the offered wage. But then in the actual H-1B, and of course, labor condition application, there will be the normal LCA calculation for the level. And if there is discrepancy, the government most likely will be asking about it, issuing request for evidence, possibly notice of intent to deny. So it's important to keep all documents how the calculation was done. So as I mentioned, for registration, we now need to have the code, SOC code, location, wage level, and we don't really need documentation because you don't have to upload or submit any documents. It's minimal. But obviously for the H-1B petition, once selected, there is extensive documentation, and it's really important that the wage level is supported. So it's really important that you actually print. Once you decide which SOC code you're going to be using and which level, you need to at least print out the printout from the Department of Labor to show, how you got your level. Very important. So let's assume somebody gets selected, they find out by end of March, and the filing starts on April 1st. So it's between April 1st and June 30th. I already mentioned the master's degree. Obviously, if you are in that boat, you will have to file, the employer will have to file H-1B once you obtain the master's degree. But during the H-1B petition stage, the full package needs to be filed, which includes I-129. Now be aware there's going to be new I-129 form. There are going to be additional questions, a lot more questions about the job itself. What kind of degree is required? What is the major? Is experience required for the position? Any specialized skill required? Is there any managerial duties? That's how they're going to be able to check whether there is a proper wage level on LCA. So this is very important, and I can see that they're going to be issuing a lot of requests for evidence regarding the wage level. And of course, supporting documents are important. All documents about the beneficiary, so passport, I-94, very important to show, especially if there is a change of status. It's important that the applicant maintained the prior non-immigrant status. Also educational documents, evaluation, credentials evaluation if needed, information about the company, and also, which is kind of new, as I mentioned, evidence regarding the wage level that will need to be submitted as well. And yeah, there will be a lot of scrutiny regarding any inconsistency if information is different in the H-1B petition compared to the initial registration. So just going back to the timelines, of course, we're already in February, so I hope all the beneficiaries are identified. There's still time, but it's really important that you start gathering documents. USCIS accounts should be, need to be confirmed, created, and just get all the information about the wage, location, so you're ready for March 4th. The registration will end on March 19. By end of March, we will know who was selected. So the lottery will happen by end of March. Filing starts on April until June 30th. And very important, especially those with the F1, that they can benefit from cap gap, which I believe last year with the modernization rule, they changed it that it's not just till October 1st, but it's up until April 1st. So if there is no decision on the H-1B, the F1 applicant can continue working up until April 1st, unless H-1B gets approved earlier. Okay, Snehal.
Thank you. Okay, so here is the $100,000 question. the $100,000 H-1B fee rule. So I'm just going to talk to you about what that means, who it applies to. So in September, there was a presidential proclamation that introduced this new $100,000 supplemental fee for certain petitions. It went into effect on September 21st, 2025. So all H-1Bs that are filed prior to this, it doesn't apply. All H-1Bs filed after September 21st, 2025, it applies to. So of course, all our cap cases that we're going to be filing, it could apply to that. So who has to pay this fee? So it applies to new petitions specifically when the employee is outside the US. So really important to know. For those people who don't have an H-1B visa that's valid, primarily these are like new hires that would be doing consular processing, and also port of entry notifications or pre-flight inspections. It also can apply if you are filing with USCIS as a change of status, extension, or amendment if it doesn't get approved. Okay, so if you are in the US and you want to do a change of status and it's not approved, now you would have to consular process, right? So then it would apply in that case. You have to pay the fee through pay.gov, .gov, and you have to provide proof that you paid that. Now, the good news is that there is no $100,000 fee, okay, for those individuals who already have H-1Bs and are in the US. So if you're filing for an amendment or an extension or change of status, okay, so for those F1 students that are going to be transitioning to H-1B as a change of status, you're going to request that when you file the H-1B, and as long as you can show that you are eligible, you maintain your status, it shouldn't apply to you. Okay, so also those employees that already have a valid H-1B visa, okay, are simply like re-entering the US, it doesn't apply to them. So just make sure when you are registering for the lottery and your case is being filed that we are aware of all these situations, because you don't want to be selected and then find out, okay, now you need to travel and you're going to be stuck because your employer will have to provide evidence that they paid this fee. You're not going to be able to come back without this proof. Okay, so for planning purposes, just make sure, you communicate this information. There are some possible exceptions. Immigration can waive the fee, but it's, very rare. And, typically it has to be like in the national interest. The individual is not going to pose any kind of security or welfare risk, and it wouldn't undermine US interests. Okay, but again, these are all rare circumstances. And just to note, there are still some ongoing legal challenges about this rule. So it's possible that, this might go offline, and it is supposed to sunset in 12 months. So this September, but we'll see what happens with that. Okay, next slide, please. Okay, so Ludka talked about the H-1B cap and this annual numerical limitation or quota, but there are H-1B petitions that they don't count towards the cap, meaning that they are cap exempt, okay? And so these are, of course, individuals who already have H-1B status and have been counted against the cap. So if you're filing for, let's say, an extension, a change of employer, like a transfer, or a concurrent H-1B that David mentioned. These are cap exempt because you already have an H-1B. You've been counted towards the cap, okay? But then we have certain employers that by statute are exempt from the annual cap. That means that any H-1B petition can be filed by these employers, initial, a transfer, and they're automatically cap exempt. And these include institutions of higher education, so accredited US colleges and universities, nonprofit organizations that are related or affiliated with these institutions of higher education, nonprofit research organizations that are primarily engaged in basic or applied research, and also government research organizations. So these employers do not have to go into the H-1B lottery. So a lot of times we also, tell our H-1B candidates who are not selected that that could be a potential option for them, to explore opportunities for an H-1B with these employers that are not cap subject. And again, keep in mind, as David mentioned, it doesn't have to be a full-time employment. It could be part-time. And also an interesting thing is that if you have a cap exempt H-1B, you can still work for a cap subject H-1B employer by filing a concurrent H-1B without going into the H-1B lottery. Okay, as long as you keep the H-1B cap exempt H-1B position. So you could do both. So that's another workaround. Okay. These are, again, some strategies that we can, potentially explore. So we talked about, or mentioned rather, the LCA, the labor condition application. So this is basically a form that the employer has to file with the Department of Labor before they can file their H-1B petition with immigration. So USCIS is not able to approve your H-1B unless there's a certified LCA. Basically, the LCA, it ensures that the employer hiring the H-1B worker is not going to harm US workers. And in the LCA, the employer makes key promises or attestations to the Department of Labor. The first one is that they're going to pay the required wage. So the employer has to pay the higher amount of the prevailing wage or the actual wage to the beneficiary, whichever one is higher. The employer also is promising that they're going to provide proper working conditions, right? That by hiring this foreign national, they're not going to adversely affect other workers, with hours, shifts, or benefits. The third promise or attestation is that there are no active strikes or labor disputes at the work site. And the employer has to give notice to US workers that by way of posting, that there is this LCA that's being filed. And if there is a union, that notice of the LCA has been provided to the collective bargaining representative. And also the employer has to provide the notice to the H-1B beneficiary. The LCA is filed online through the Department of Labor's flag portal, and it typically takes 5 days to get the LCA certified. And the employer has to make the LCA available for public inspection within 1 day of filing the LCA. Okay, next slide, please. All right, so H-1B employers who sponsor workers, they have certain things that they have to comply with, the Department of Labor and USCIS. And some of these obligations begin before you file, during the employment, and then also once the employment is has ended. Okay, so the first one is not only does the employer have to pay this required wage, but they also have to pay the wage even when work is not available. So they have to pay for non-productive time. They can't bench an employee and say, well, I don't have work for you this week, or the project is over and I can't pay you until we have a new project. So benching is not allowed. That's an obligation. Also, if the employer terminates the H-1B worker before the H-1B approval period, they have to offer reasonable cost of the return transportation back home. And typically that's done by the employer by sending a letter to the H-1B foreign national that says, your employment is terminated. Please contact us so that we can pay you for the return cost of your airline ticket. That's pretty much, all they need to do. I would say an overwhelming majority of the time, the foreign national transfers that H-1B visa because they typically will have a grace period, 60 days or less if their I-94 expires before 60 days. So most times these individuals are transferring their H-1B because they don't want to go back if they're able to find another employer to transfer the visa. Okay. Another thing the employer has to do to cut off this obligation to pay the wage is they have to notify USCIS that the H-1B individual has been, terminated. And then they would also withdraw the LCA. They also have to maintain a public access file. And, I'm going to talk a little bit more about that. And if there is any kind of amendment for the H-1B petition, right? If there's a material change in employment, the employer has to file an amendment with the USCIS and also file a new labor condition application. So, for example, if there's a new work site, this is really, really important. If the foreign national is working from home and now they're moving or they're going to another work site, okay, there has to be an H-1B amendment that's filed. And this is based on the Simeo case, which talks about this material change. Also, full-time to part-time or part-time to full-time is considered a material change. A lot of times employers are not aware, but that is important to note, and an H-1B amendment will have to be filed. Also, if there's a major change in the job duties, now, we're not talking about a promotion within the occupation, but if you're talking about significant changes where maybe a different type of degree might be required and the beneficiary has that, or it's a related degree that the beneficiary can still work under H-1B, that would be deemed a material change requiring an amendment. Okay. And also the employer has a continuing obligation to update the public access file. Okay, so let's talk next about what is the public access file or PAF. This is a set of documentation that the employer has to create and keep on site to show that they are complying with the LCA requirements. And anybody, including an employee, Department of Labor, even a competitor, can ask to see the public access file. And when you have a potential audit by the Department of Labor, they need to see the PAF. So it's really, really important to maintain this. And, unfortunately, what we found over the years that a lot of employers are not aware of what this PAF requirement is. Even if they have maybe counsel that's representing them for the filing, they're not keeping the PAF, and it's super important. So what do we have to include in that? So we have to include wage documentation, okay? We have to include a copy of the certified LCA, wage information, how did you calculate the wage? Department of Labor, OES printout, the prevailing wage source has to be kept in there. Proof of the posting. You need to provide evidence that you posted the LCA, in 2 locations for 10 days. So you take like the screenshot. We have to keep that in there. Also, if there are some changes to the corporate structure, that information needs to be on there. Also, summary of your benefits that you're providing to the H-1B beneficiary, that they are the same, to show that they're the same as benefits that you're offering to all your other employees. Okay. Really, really important. The PAF is not the employee's HR file. Okay. So personal documentation, like tax documents, the offer letter, even the H-1B petition documents, right? These are not things you keep in the PAF. You can keep that in the internal HR file for the employee. Don't keep that with the PAF. Okay. Because why? If there is an audit and you have to provide this PAF, all of this other documentation now is going to be made available for inspection, and you don't want to do that. The employer has to keep the PAF for at least 1 year, after the end of 1 year after the end of the LCA validity period, or 1 year after you withdraw the LCA, whichever one is later. Next slide, please. So What happens if you don't maintain your path? Okay, so for those of our employers, and maybe they don't have a path, just beware that if you don't have one or you're missing key documentation, it could lead to like a broader investigation of your LCA practices and all your H-1B filings. And if there are some severe violations, you could be charged with some, penalties by the Department of Labor. Okay. You also, per violation, you also could be debarred, if you have these repeated violations. You could be debarred for filing H-1Bs for 1 to 3 years. So it's not something to take lightly, especially if you have, a number of H-1B beneficiaries, not only currently maybe that you're going to do the lottery registration, but existing workforce that's on an H-1B. Really, really important to make sure that you have accurate paperwork for your paths. Okay, I think that's pretty much where I end. And now, David, you're going to talk about the I-9 compliance.
Well, you actually gave me an awesome springboard, and I thank you for that, to talk about the unsavory issues of enforcement, because this is within the bailiwick, of course, of the HR usually in the organizations that we work with, but oftentimes it falls into different components of the organization. Sometimes it's the CFO, sometimes it's the CEO. So where does enforcement come from? Well, one of the really difficult parts of immigration law is that it could come from a variety of different administrative agencies. So with regard to H-1B in particular, we're just going to parse it out for you. You could get enforcement from FDNS. That is the Fraud Detection National Security Division of the U.S. Department of Homeland Security. Those folks are coming to your premises, oftentimes searching to find out whether or not the H-1B is working where they're supposed to be working, that they're getting paid what they're supposed to be getting paid, and that they are in the positions that they're supposed to be in. So we are anticipating, especially with the huge amount of money that went to that went through the big, beautiful bill to the various administrative agencies that conduct these investigations and do the enforcement, that there's going to be an uptick in this type of enforcement. So FDNS is likely to be out there doing site visits, and also because they're going to be looking to ensure that there's a streamline between the registration and the actual H-1B. We also have ICE out there doing I-9 audits. Of course, I-9 audits are something separate. We'll talk about those in a second. That's what this slide is about. That's Immigration Customs Enforcement, a subdivision of also the U.S. Department of Homeland Security. And also with H-1Bs, as I mentioned previously, so we're kind of coming full circle, is that the H-1B became sort of an animal also of the U.S. Department of Labor. So the U.S. Department of Labor Wage and Hour Division is out there to ensure that the individual is actually getting paid on a W-2 what they're supposed to be paid as per the labor condition application, which Snehal and Lutka both alluded to and discussed sort of more in depth. But I think that it's really important to also bring to everyone's attention, especially HR attendees who are interested in the H-1B, that they did recently announce a new program. It's called Operation Firewall. Operation Firewall is going to be it's going to bring together communications between these administrative agencies. So where you saw before, let's say, the U.S. Department of Labor coming and knocking at the door, and where you saw FDNS coming, knocking at the door, and ICE knocking, now they're probably all together. They're going to be doing enforcement actions together. And that's, by the way, something that we haven't not seen in the past. We've actually seen various administrative agencies and their enforcement arms working together. So I think we're going to see a step up in that, especially now that algorithms being run, through various databases will probably be able to more easily come up with inconsistencies. So it's more likely that we're going to see that kind of thing. With regard to I-9 compliance and H-1Bs, needless to say, I-9s have to be done for all employees. There is a new form that's out there. Why is this important for beneficiaries? Well, beneficiaries of H-1Bs may want to potentially do new I-9s when they get their H-1Bs, but they don't necessarily have to if their employment authorization is going to, let's say, straddle over October 1st, when your H-1B might potentially be active. However, that would be really a policy that's up to the employer. So if your H-1B, however, is expiring, and this is more for something in the future, if you file your H-1B extension, you'll be able to get 240 additional days of work authorization. And that, of course, that was changed back from the 540-day, which was under the Biden-Harris administration. But needless to say, it's important to re-verify. HR managers need to know that. And also the I-9, when you're dealing with portability provisions under AC-21 and you're moving your H-1B from one employer to the next, then you would have to deal specifically with the special I-9 rules, which are in a document called an M-274. It's called the Employer's Handbook, and it's really what I refer to as the Bible, on dealing with I-9 forms. We'll go to the next slide, please. Thanks so much. So actually, Lutke and Snehal, you did a really good job of telling our attendees what issues they need to be preparing for. And I just want to, yesterday, as I said, there was a practice guide that came out from the American Immigration Lawyers Association. And so what they did is they actually put forth what the registrations, what our clients need to be concerned about for registration. So I'm just going to go quickly through this list, and I think you did a great job of already going through it. So I'm just hitting on things that you already said. But the first thing that we're going to need to do is to identify the SOC codes as per the Department of Labor standards. Okay. Secondly, we're going to need to identify the areas of employment or the worksite locations. Third is any offered salary for the H-1B position is going to need to be tied down. And also the wage levels 1 through 4, that's going to need to be tied down. And then, as I think Lutke, you had mentioned, maintaining the evidence and printing out the OES wage from screenshots and from flag is going to be really important. So these are all things that, and this goes to the first point here, is this is what you need to do in terms of your upfront analysis in order to be properly prepared for the registration period, which again begins on March 4th. So the other thing that we do is we look at preparing for the possible RFE, which in the past, the RFEs focused a lot on specialty occupation, and they also focused on other issues. So we're sort of used to dealing with RFEs. However, we anticipate that there are going to be more inquiries in the area of wages and the SOC codes. So we're going to probably be working with our clients now to start to gather up the evidence so that we can justify which SOC code we chose and which wage level we chose and why. And
I just want to mention, David, because I see some of the questions. I think the government is going to be closely looking at amendments, for example, or transfers later on after October 1st, especially if, let's say, it's amendment to a lower wage. So government may be scrutinizing it just to see if there was some fraud involved to have a better chance in a lottery, by assigning higher wage level, especially if come October 15, the employer will file an amendment to the lower wage, or if the individual transfers, suddenly to much lower wage. So, I'm getting a lot of questions from applicants
I agree
regarding that,
Yeah.
and also
I agree, Lutka. And
remote location.
Yeah.
I'm kind of concerned. I had several people.
Yeah, I agree, Lutka. And
Go ahead.
Yeah, I do agree, I do agree, Luca, and I also think that that's what Operation Firewall was all about. They announced it because they want to give notice now that there are going to be enforcement actions, and I believe they probably have already thought about what those algorithms are going to look like to figure out when those changes are material enough to send out the enforcement officers. I absolutely agree with you.
Now, having said all of this, I think that there's a good chance that even though a level one wage will get one shot, I think there's a I personally think there's a better chance of being selected this year because a lot of our clients are concerned, and rightly so, with the wage selection, the $100,000 fee rule. But I do think that this might be, the best time to put somebody in the lottery because you will have, especially if it's a higher wage level, a better chance or more chances of being selected. So I think that we'll see
Because
lots of changes.
it's
I
important to
agree. And
choose the right code
yeah, I'm
and
sorry.
right wage level because, that's a little bit concerning, especially if employers will do it on their own. They would just select whatever occupation, then we would, it's not possible really to change it, the SOC code. So that's a huge difference, as we discussed throughout this hour, that this is a huge difference. That now you do have to select
Yeah.
SOC code and level because they will be looking for consistency.
Yeah, but the level, from my understanding in the final rule, the level can be different because that analysis is going to be different than the
Correct.
initial wage level that we need to indicate when we do the registration.
Correct.
But the actual classification, the SOC code, that, needs to stay the same, needs to be consistent. So, but again, lots of these technical requirements, we're here and happy to answer your questions. We'll do the analysis, hopefully before all of the registration period starts so that it'll be as smooth sailing as possible.
Exactly. And I think that overall, it's been a bit of a weeding out. I think that this is what the government is striving for is to make the H-1B process what it really should be, and that is a visa designed for the best and the brightest. And that's, I think, slowly what they're doing, even though it's a dynamic process, is they're slowly getting to that by weeding out folks who maybe should not necessarily be, in the process. But
Well, one would argue the best and the brightest make sense, but they also don't have to be paid the highest wage level. And I think
that's
that's the big problem here.
and that's why
Yeah.
it's a dynamic process. So we'll see how it all shakes out this year for sure.
Yes,
Yeah.
So
definitely.
So
as you rightfully said, so if anyone needs any assistance, please feel free to call upon us. I put our email addresses and our website into the chat or the Q&A, so it should have been available. The questions were excellent. Thank you so much. I don't know how many we were able to answer, but we are at the top of the hour, and I want to thank everyone who attended. Thank you so much for your attention, and if there's any way we can be of assistance, please feel free to call upon us.
and
Thanks
of
so much,
course, good luck in a lottery.
and good luck in the lottery.
Mhm. Bye now.
Bye.
Bye for now.